So we were speaking a moment ago about the investigatory powers bill. We're here with Jim Killock, who's the executive director of the Open Rights Group in the UK, and Mike Keys, my co-host, is here with me too. I'm Denise Howell. And we've been talking about various aspects of the investigatory powers bill in the UK. And one thing that comes up, and one thing that I think is an open question in that bill, is the extent to which it conflicts with laws on the books in the United States and stances that companies such as Apple have taken in the United States about whether they're going to backdoor their devices so that in the event a locked iPhone, for example, is in the hands of law enforcement in the UK, whether they will have an avenue to unlock it, even if they don't have the passcode or a fingerprint to do so. Well, until we get all of those legal questions answered and ironed out, the UK police are trying a different tack. And what that is in a couple of instances, they have staged a robbery. They've been tracking a suspect, following them. They wait until the suspect gets a phone call, and then they stage a robbery and actually snatch the phone out of the person's hand while it is unlocked. And then I suppose there's an officer whose job it is at that point to make sure the phone stays active and doesn't lock again until they can get it to the station and download the data. Had you heard about this, Jim?
Yeah.
I think here in the United States, some criminal procedure lawyers would have some arguments to make about whether that's a reasonable search and seizure under the Fourth Amendment. It could be, and you might have a warrant in your hand for the phone, in which case I would say snatching the phone would probably be okay. But to do so without a warrant in the U.S., I think at least is subject to challenge. Tell us more about this, Jim.
Well, I don't know much more about the story than you've already stated, but there have been a lot of things going on in the UK around this, which have been pretty dodgy down the years, kind of regarding phones as roughly the equivalent of something like your wallet. And if you are seized, so if you're taken into custody, then the police got a right to look in your wallet and so on. And so they've kind of extended that metaphor to your phone and just said, well, we'll download your phone's contents while we're at it. And that's one of the reasons they've got annoyed with the idea of encryption on phones as routine, because it means they can't simply swipe what's on there. I could, also mention that it's led to there's a whole thing of kind of grabbing people's phone content has led to some fairly difficult situations. Our colleague at Open Rights Group, Miles Jackman, is a lawyer who's been, working on various kinds of obscenity laws down the years, as well as privacy and free speech. And he has represented people who've had their phones seized, and then images have been found on those phones which have broken UK obscenity law. Consensual acts depicted in photographs, shared between friends or whatever. And of course, those images might break a law, obscenity law. Then the police have attempted to, prosecute those people for the images rather than the things that they arrested them for. So I think there are good reasons to not allow police to just grab content off phones for undefined purposes, because they are given these opportunities to really abuse their powers.
In the UK, is there a different standard? And we have an unsettled standard, I would say, here in the United States for when law enforcement can compel someone to give over a passcode or a fingerprint and unlock a phone?
Well, there is within RIPA it is an offence not to hand over passphrases and encryption keys. That is actually an offence, and you can go to prison for it. I mean, they have to, I think, have some suspicion already. You have to be under investigation before they can compel that. But nevertheless, they have that power, and people can be and occasionally are sentenced for it.
We've seen courts in the United States go back and forth over passcodes versus fingerprints and what can be compelled, what a suspect can be compelled by the police to give over. And in fact, just in the last week or so, we've seen an interesting case out of the state of Florida, an appellate court there that sort of went against the majority of cases in the U.S. and found that not only can fingerprints be compelled, but providing the passcode, which is not a bodily kind of thing like a fingerprint or a blood sample or a urine sample, but the passcode that's held in your head. Many courts in the United States have found that compelling that sort of information violates our Fifth Amendment right against self-incrimination. This appeals court in Florida decided no, that there's really nothing different, no difference between providing a passcode or a fingerprint to unlock a phone. And this suspect could be compelled to make what the court called a non-factual statement that facilitates the production of evidence for which the state has otherwise obtained a warrant based on evidence independent of the accused statements linking the accused to the crime. So again, we see our courts struggling with that. And I was just wondering, aside from simply snatching the phone out of someone's hand while it's still active and downloading, I wondered if you had more clarity on the issue in the UK. And it sounds like in the UK, you could be compelled to provide either thing.
Yeah, that's right. You can. They already have that power to compel you to do that, and it is simply a criminal offence for people to try not to.
Right. Mike, any thoughts on the Florida case?
Well, I thought it was very interesting, and interesting to see how the courts are dealing with these issues. You know, it brought me back to my criminal procedure class years and years ago in law school. It seems like some of these distinctions that courts make are a bit artificial, like the U.S. Supreme Court case that was cited by the federal appellate court. You know, in that U.S. Supreme Court case, you know, the court said you can force somebody to essentially give you a key to a lockbox, but you can't force them to tell you a combination to a wall safe. And, you know, the distinctions that are made by the court sometimes, it's kind of hard to understand the reasoning and rationale. But the other thing that when I was reading the story about the UK police snatching the phone, it brought me back to this whole notion of why we adopted the Fourth Amendment to begin with. And of course, a large impetus for that was back when we were still a colony. The British troops could come to your home and exercise these general writs of assistance, and they could seize anything essentially that they wanted, and they could enter your home for any stated purpose or no reason at all. And so that was, to a large extent, why we ultimately, or the framers ultimately, adopted the Fourth Amendment that required probable cause, and you needed to go before a detached and neutral magistrate and ultimately get a warrant before you could do any search and seizing. So interesting to see the contrast between how U.S. courts are grappling with these issues and how it seems to be a much more settled issue there in Britain. So.
Well, I think the thing is that in the UK, we haven't dealt with it as a matter of principle. So, you know, you've gone through the question of why should government have arbitrary power, but in the UK, it's always a question of, well, are we sure that the police are able to investigate? That's the kind of starting point, and of course that's a reasonable question, but you know that only takes you so far.